Good afternoon, everybody, and thanks for joining us for the September event in Kahn Carey's 2021 OSHA webinar series. I'm delighted that you've all been able to join us and that we're going to be talking mostly about something other than COVID-19, a refreshing break from the near continuous and relentless focus on the pandemic over the last year and a half. Today, we're going to be talking about OSHA's electronic record-keeping rule, which was one of the most significant regulatory developments during the Obama era at OSHA. And it's, as one of the new and exciting developments at the agency, there's been a lot of change as it's been implemented since it was went into effect in 2016, and it continues to change. It continues to be on the regulatory agenda, potentially for even more changes coming soon during the Biden administration. So we thought this would be a good time to revisit the rule, talk a little bit about what electronic record keeping is, what's required by this rule, how it's changed over its short life as a regulation, what we see for it coming soon during the current administration, and the various implications of this relatively new regulation that requires employers to share injury and illness data with OSHA. We'll do some quick introductions. The first faceless voice that you're hearing today is Eric Kahn. I'm one of the founding partners at Kahn Carey, and I chair the firm's National OSHA Workplace Safety Practice Group. I've practiced for more than 20 years now, essentially exclusively in the field of workplace safety and health law. The first decade or so, I practiced alongside the first general counsel of the OSHA Review Commission, and have worked at a couple of other law firms before 7 years ago, almost to the day when we launched Kahn Carey to focus on workplace safety and health regulatory issues and labor and employment issues. And our practice, my practice, our team, focuses on sort of soup to nuts, top to bottom workplace safety and health regulatory issues. We work with our clients, employers, to help manage their interactions with OSHA and other agencies that get involved in safety and health issues, from inspections, investigations, enforcement actions, and even more often these days than we'd like, criminal investigations and prosecutions. But also work proactively with our clients to develop compliant safety and health programs, to audit those programs, and to provide advice and counsel. And over the last year and a half, I thought I was a specialized attorney focused on OSHA issues. Really, I've become even more specialized, focused on infectious disease issues within workplaces because of the COVID-19 pandemic, and working closely with our firm's multidisciplinary COVID-19 task force. And it's been an obsession, like I'm sure it has been for many of you, to manage this crisis in the workplace. We've been working tirelessly over the last year and a half to help our clients navigate that particularly tricky landscape. So I'm delighted to present for you today, and I'm delighted as well to be joined by two of my colleagues, Lindsay Desalvo and Dan Deacon. I'll let them introduce themselves, and then we'll jump right in.
Thanks, Eric. Good afternoon, everyone. My name is Lindsay Desalvo, and I'm an associate at Kahn Carey in both the OSHA and employment practices. And in the context of our OSHA practice, record keeping is a huge issue that we deal with, I would say, probably on a daily basis. There's a lot of nuance to the record keeping and reporting standards, as well as the E-Recordkeeping standard that will take some time to review today. So that is definitely a significant part of our practice, and assisting clients with developing policies and practices that align with the requirements of those particular standards. As Eric said, we've definitely spent a lot of time in the COVID world over the last year and a half. And record keeping has also been a significant part of that, which we will talk about a little bit today. So with that, I will pass it over to Dan to introduce himself.
Thanks, Lindsay. My name is Dan Deacon, and I'm also an associate here in the Washington, D.C. office. I work in both the OSHA practice group and the labor and employment group, representing employers during inspections and investigations conducted by state and federal OSHA, assist in a variety of different labor and employment issues, revising employee handbooks, and an array of litigation related to discrimination and wage and hour claims. As it relates to the E-Recordkeeping Rule here, I've been following this closely since 2016 when the rule was first introduced. And I'm well versed in the injury tracking application where you need to submit the data. So any questions that you may have during the presentation today, just a reminder, you can ask a question in the chat function, and feel free to reach out to any of us on the presentation here on the panel with questions afterwards.
All right, so what are we going to be covering today? I guess I lied a little bit when I said COVID-19 was not on the agenda. I think we're contractually obligated by our sponsors to talk about COVID-19 in every webinar we present this year. So we will get into that a little bit, but the primary focus is the electronic record keeping rule itself. It was promulgated back in 2016 and has changed a little bit during the Trump administration. We expect some changes coming during the Biden administration, or maybe a revision or reverting back to its original intent. We'll talk a little bit about that. Both the data submission elements of the rule as well as the anti-retaliation elements of the rule. We'll get into a little bit of interesting data about the e-record keeping rule, submissions by employers, as well as some enforcement information where the agency has been focused since they promulgated the rule. And then we'll talk a little bit about the implications of this rule that requires employers to proactively share their injury and illness data with OSHA in a way that had never been done before, or never been done in sort of the mass levels that we are doing that now, and principally how that affects OSHA's overall enforcement strategies. And then finally, we will get into a little bit of COVID-19 record keeping and how that intersects with everything else we're talking about today, with injury data submissions and OSHA enforcement around those issues. So I think I'm handing it over to Dan first to get into the mechanics of the rule.
Great. Yep. So we're going to start out first talking about the electronic injury and illness data submission requirement. This rule was finalized in May of 2016, May 12, 2016 to be specific. And this was after years of proposed rulemaking, several comments from employers. This proposed rule received significant backlash from the industry, and there was two key major provisions that came out of this rule, the final rule that is, and that was one, establishments with 250 or more workers must annually submit to OSHA their 300 logs, their 301 incident reports, and their 300A annual summaries. And then establishments with 20 or more workers in high hazard industries were required to submit 300A annual summaries. And that high hazard industries list was an appendix to the rule done by the employer NAICS code. So that encapsulated a wide swath of employers that were out there throughout the country that fall within this high hazard industry. And it's important to ensure that you are or are not within that high hazard industry list if you're unsure whether you need to submit data in the first place. So if you are an employer with 20 or more workers at one of your establishments and you're unsure whether you're in a high hazard industry, we recommend taking a look at that list and first, of course, understanding what your NAICS code is and evaluating whether you fall within that high hazard industry list. And we're going to talk a little bit about the data of how many submissions have come through over the past few years. We're at the stage now where this rule has been in place for about 5 years, and there's been several rounds of submissions, but we haven't quite reached the levels that were anticipated of the number of submissions that were anticipated by OSHA. In fact, we're right about around half of what OSHA anticipates receiving on an annual basis. So moving on to the next slide, what was the original rule itself, and what was it supposed to be as it relates to this electronic injury data submission requirement? Well, you're supposed to be submitting data electronically through a secure website, and it took OSHA a little bit of time to develop this website, and there were some delays in rolling out the data submission requirement, but we now know that that's called the injury tracking application. It's a website where employers are supposed to create an account for their establishment or for their company, And there's different ways that you can submit data. You can submit it establishment specific, or you can use a CSV file. If you're a large employer and you want to submit data on behalf of numerous establishments that are covered under the rule, you can do that in one fell swoop. OSHA was attempting to scrub employee identifying information. Again, this was a concern related to the submission of the 300 logs and the 301 incident reports. And OSHA had committed to making sure that they were scrubbing that employee identifying information, because the original intent, of course, was to publish that injury data to the public and post that on a website for anyone and everyone to see. And what was the purpose of this rule? Well, it was going to be used, and it is, now we know that it is used for targeted enforcement purposes. And we're going to talk a little bit later about the site-specific targeting program that OSHA has launched. We're on the second iteration of that SST program now in 2021. So we're going to go over that in a little bit more detail later. But that was the intent of collecting this data, is to evaluate employers' DART rates and identify those industries with elevated rates for targeted enforcement purposes, and going in and inspecting them on a proactive basis. So moving on to the Trump administration and what happened in 2016, of course, when this rule was finalized. That was finalized under the Obama administration. There was a lot of anticipation that the Trump administration would come in and narrow down the rule, cut a lot of the regulatory requirements that were contained therein, including the data submission requirement, as well as the anti-retaliation elements related to drug testing, safety incentive programs, and executive compensation. And we're going to talk about those in a little bit more detail in a few slides here. But as I mentioned, industry had long opposed this rule for several years, even prior to finalizing the rule itself. There were several legal challenges that were brought following the publication of the rule, both related to the data submission requirement and the anti-retaliation elements. We won't go into too much detail about each of those, but there were two seminal cases out in Texas and Oklahoma related to these two elements of the rule that were initiated shortly after the rule was finalized. But then we got a transition into the Trump administration, where the deregulatory agenda was really rolling out at a fast pace. And this was one of the first things that they were to address, was OSHA's E-Recordkeeping Rule. It took some time to get there, but in July 2018, they issued the notice of proposed rulemaking. And to some disappointment to industry, it only had these two elements in there. They were going to eliminate the requirement for large establishments, those with 250 or more employees, to submit their 300 logs and their 301 reports. This really wasn't that big of a change, because OSHA hadn't collected 300 logs or 300 reports up until that point anyway. The injury tracking application hadn't been set up to collect that data at all. So as of July 2018, when this notice of proposed rulemaking was rolled out, that requirement in the original rule to submit 300 logs and 301 reports hadn't surfaced. There had been no submission of that data at all. But that was part of the notice of proposed rulemaking, taking that out of the original rule altogether. And then they added a requirement for establishments to submit their employer identification number. That rule was finalized in January 2019, adopting both proposals. During that rulemaking process, there was several comments, again, requesting that the anti-retaliation elements be dropped, and to even further reduce the burden on employers submitting this data, in attempts to wipe it out altogether, to eliminate the rule. But that did not happen. The amended rule didn't address the publishing of data to the public, which was the original part of the rule, and one of the key pieces of this notice of proposed rulemaking that industry was really pushing to remove. And it didn't address the anti-retaliation elements at all. And there is anticipation that the Biden administration is going to revisit this rule in an attempt to revert it back to the original scope. There's a lot of push from labor industries and organizing groups that want to reinstitute that rule as it was intended back when it was published in May of 2016. So where do we stand right now? The key data submission deadlines. So looking at the next slide here, we see kind of the transition of where we are today. As of 2018 and beyond, when that rule was amended under the Trump administration, we're only required to submit 300A data, and those are for establishments with 250 or more employees, as well as establishments with 20 or more employees in a high hazard industry. And the deadline to submit those is March 2nd on an annual basis. You do that again through the injury tracking application. Moving on to the next slide, I talked a little bit about the importance of the original intent of the rule to publish the employer data on a publicly available website. The Trump administration had originally rejected that plan to publish employer data, and it hadn't been done. They refused to share the data pursuant to FOIA requests, and that was at least on a temporary basis because there was a challenge brought by public citizen to OSHA's withholding data under a FOIA request. And what came of that was an opinion by a federal court here in DC, where the magistrate judge recommended that the district court deny OSHA's motion for summary judgment and grant public citizens cross motion for summary judgment because those requested records, the 308 data that they requested pursuant to FOIA, it did not meet one of the exemptions. So shortly after that, within a week or so, OSHA announced that it would not file any objections to that report and recommendation, and that they would be producing those requested records. Shortly after that, it took a little bit of time, late summerish, OSHA published the 300A data online in a publicly available website. And right now that contains all of the collected data from calendar years 2016 to 2020. So moving on to the next slide, you can see a little glimpse of what that website looks like. And there's links to all of the employer data that has been submitted throughout the history of the rule, with the exception of the data that was submitted in 2021, of course. That hasn't been published yet. However, any employer that has submitted data within those years, you can click on the link. It opens up in a large Excel spreadsheet, and there's 200,000 plus establishments that are listed on there with all of the data that is submitted on the 300A law. So the public has access to this data without restriction, despite numerous attempts and comments and pleas with OSHA to not publish this data, including legal challenges and defending efforts. So now we're going to take a look really quick at the e-record keeping submission data. During the rulemaking in the preamble of the rule, OSHA had estimated that they'd be receiving approximately 570,000 submissions. So in other words, there were 570,000 covered establishments that would be submitting data on an annual basis. So looking at the reality of it, let's see how many establishments are actually submitting data. So in 2016, we had about 215,000, I should say, submissions by covered establishments. So we didn't even meet half of what OSHA expected. And as you can see, as we progress throughout 2017, 2018, 2019, up until the present, we're still well short of what OSHA anticipates. In 2017, there was about 260,000 submissions. In 2018, there was about 290. In 2019, there was a little over 290,000. And then there was actually a pretty significant drop in 2020 to about 277,000, likely spurred by the COVID-19 pandemic. But this is just a glimpse to show you how many covered establishments are actually submitting data compared to what OSHA actually expected when they initiated and promulgated this rule. So on the next slide, we are going to discuss the e-record keeping citations and kind of get a glimpse of what enforcement around this rule has looked like. So as you can see on the ledger at the top there, we have 3 different regulations. 1904 41A1 is the requirement that establishments with 250 or more employees submit 300A data. And the corollary there, 1904 41A2 is the requirement that establishments with 20 or more employees in a high hazard industry submit their 300A data. And then finally, 1904 35 B1 subsection 4, that is the anti-discrimination and anti-retaliation provision prohibiting employees from violating those anti-retaliation elements or otherwise discriminating employees for exercising their rights. So looking at fiscal year 2018, under 1904 41A1, the requirement for establishments with 250 or more employees to submit data, there was 16 citations, 98 citations for those employers, establishments, I should say, within high hazard industries, 98 citations. Going to fiscal year 2019, there were 11 citations issued for establishments with 250 or more employees for not submitting that data, 113 for high hazard industry establishments with 20 or more employees. And then there was a significant drop here in 2020. And that's likely because of the COVID-19 pandemic and resources being diverted elsewhere, but they were still looking and enforcing these provisions. The majority of all of these citations that were issued under the e-record keeping rule are other than serious citations. OSHA issued an enforcement memo several years ago outlining what those protocols were for the compliance officers inspecting these issues to do. And the instruction is that the citation would be issued as an other than serious, and there is opportunity for employers to correct that. But the importance here is OSHA is enforcing these, and although you might see an other than serious record keeping citation, that is very important for the future, right? Because it is very easy to find yourself within a repeat characterization because record keeping is such a prolific issue throughout the industry. It's very easy to spot, right? During any inspection, OSHA is going to be asking for your record keeping records. They're going to ask and make sure that you did submit your data if you are a covered establishment. So it is something that is very easy to track, and you should think twice if you do receive a record keeping citation for failure to submit the data or any record keeping issue, period, whether that is something that you should accept. And we typically advise that you should never do that because of that likely risk of a repeat, especially large employers, nationwide employers that operate in several Fed OSHA jurisdictions. There can be a repeat characterization because one of your establishments on perhaps the West Coast or somewhere else, the Midwest, failed to submit data 2020, and one of your establishments on the East Coast in the Fed OSHA jurisdiction accepted a citation under one of these provisions a year or two before. So it is important to make sure that if you do get one of these citations, to think carefully before accepting one of these OTS citations. And typically they have a very small penalty, but the significance of that down the line could be much greater. So with that, I'll turn it over to Lindsay to talk a little bit more about the anti-retaliation elements.
All right, thanks, Dan. So the other outcome of the e-record keeping standard was the anti-retaliation provisions that also went into effect. And these were sort of unexpected when the rule came out. and have been challenged by employers as sort of a thing that is totally separate from the e-record keeping standard and the original intent of the e-record keeping standard, but also something that was already sort of in place. Section 11C of the OSHA Act provides a way for employees to make claims of retaliation against an employer related to reporting safety issues or, reporting injuries and things like that. So it's also seen as something that was kind of unnecessary based on the already existing framework. However, the anti-retaliation elements did go into effect along with the rest of the record-keeping rule. They were not removed or impacted by any of the changes made to the e-record-keeping rule under the Trump administration. And so we do want to make sure that we go through those as well, because the impact of the anti-retaliation provisions can be significant and important to consider in the development of policies and practices of the employer. So there are sort of three main buckets that the anti-retaliation provisions fall into. And the first is internal injury reporting policies. So per the anti-retaliation provisions of the e-record keeping standard, OSHA has said that employers must develop internal injury reporting policies that do not discourage employees from reporting injuries. So it's important to make sure that the policies and practices in place for injury reporting would not deter an employee from actually making an injury report. And the two main issues that come up related to the requirement to have reasonable injury reporting policies is first disciplining employees for late injury reports. And what OSHA says there is that the employer must have a policy in place that is reasonable in allowing an employee to report an injury where an employee either is incapacitated by the injury or may not realize that they've been injured at the time that the incident occurs. So OSHA has found it problematic to have a policy that requires the employee to report within, 6 hours of an injury, or by the end of the day that an injury or that an incident occurs, or within 24 hours of an injury. OSHA has sometimes found to be unreasonable as well, simply because in OSHA's view, the employee may not always know that an injury has occurred by that strict period of time in which they need to report. So OSHA expects employers to have a reasonable policy, and what they've highlighted to be a reasonable policy in the context of injury reporting is something along the lines of having to report an injury as soon as practicable. And then the second sort of issue that arises related to this is enforcing vague work rules. So OSHA sees vague work rules like the examples here, things like work safely or maintain situational awareness, as problematic because they could potentially be manipulated by the employer to specifically discipline those who report an injury or an incident. And so in that context, what OSHA is really looking for when it evaluates the implementation and enforcement of a work rule is whether the rule is being consistently implemented. So if you have an employee who has a forklift accident and receives an injury, reports that injury, are they being disciplined in the same way as an employee who has a forklift accident that does not result in an injury, but the same maybe work rule is violated? Are they both being disciplined, or is it just the employee who reports the injury that's being disciplined? So OSHA wants to see that the employer is applying its rules in a consistent manner, and that those who are reporting injuries related to an incident or a violation of a safety rule are not the only ones that are being disciplined for the same standard as all other employees at the facility. The second bucket on the next slide is drug testing. So OSHA has also applied its anti-retaliation provisions to drug testing, and in its guidance has set sort of a limitation on drug testing related to these anti-retaliation requirements. And the idea here is that OSHA believes that having a certain drug testing policy, such as across the board drug testing for any type of incident that occurs, could impact an employee's willingness to report. The employee might be dissuaded from reporting if they're concerned or afraid of being drug tested because they report an injury or illness. Although drug testing is not permitted to be used as a form of discipline under the anti-retaliation provisions, OSHA does recognize that drug testing can be an important and necessary tool to evaluate the root causes of a workplace injury, to determine why a workplace incident may have happened that led to an injury. So the rule really only prohibits drug testing an employee for reporting a work-related injury without an objectively reasonable basis for doing so. So OSHA is looking here at whether, in applying a drug testing policy, the employer has a reasonable basis to drug test the employee. And the central inquiry in that regard is going to be whether the employer had a reasonable basis to believe that drugs or alcohol could have contributed to the incident that caused the injury or the injury itself. So for a drug testing policy and application of a drug testing policy to be compliant, there should be a reasonable possibility that drug use by the reporting employee was a contributing factor to the reported injury or illness in order for the employer to require that the employee be drug tested in that instance. And, you know, the example that we kind of use to illustrate this is if you have a situation where, you know, going back to the forklift accident example, a forklift operator who is injured when they, you know, crash into an object at the facility, is it reasonable to drug test the forklift operator in that instance? Probably. Particularly if there was evidence of reckless operation of the forklift, because there is a reasonable basis to believe that if the employee was intoxicated, that could have contributed to the incident occurring. On the other side of that, OSHA would likely see it as problematic if an employer decided to drug test someone who had, you know, like an allergic reaction to a bee sting, or they had, you know, strained a shoulder or the back while they were reaching for something. The fact that they are intoxicated would not really matter in those situations, or be something that could have contributed to the injury itself. And so OSHA is likely not going to see it as reasonable to drug test the employee in those circumstances. Another situation to think of in this context is if you have a situation where there is, you know, an accident with a forklift, if there were other employees involved, if there was, you know, a signal operator involved in it as well, you know, are they also being drug tested? Could their actions have been contributed to by an intoxicated state? And if so, were they drug tested even though they weren't the one who was injured or reported the injury? So if the drug testing policy is being applied in a consistent manner, then there would be no issue to the application of the policy there. One of the trickier parts of the drug testing limitation is the nature of the tests themselves. So the preamble to the final rule does talk about allowing testing that can accurately identify impairment from drug use. You know, we know that there are tests out there that can accurately identify the presence of alcohol in someone's system in a way that could impact their operation of a vehicle or, you know, their actions in the work environment. But there are not tests that are really effective in measuring, you know, the level of drug in the system or whether the level in the system would actually impact the actions of the individual. For other drugs, those tests don't really exist right now. So that can be an issue that OSHA might look at, might consider in the context of a drug testing policy. OSHA has specifically said that there are no limits to certain types of drug testing, and those are what you see on the slide here. Pre-employment drug testing is fine, random drug testing. So to avoid, those blanket policies of drug testing, if the employer is just doing random drug testing of all employees not related to specific incidents, there then cannot be that connection made to treating employees who report injuries and incidents differently than those who do not. And again, you'll see at the bottom there, post-accident is totally fine as long as there's a reasonable basis to believe that drugs or alcohol contributed. And then the third bucket that OSHA has applied its anti-retaliation provisions to are safety, incentive, and bonus programs. And this slide just shows sort of an overall picture of the types of things that OSHA tends to favor in the context of safety incentives and tends to not see as really problematic, and those actions that they see as more problematic and potentially dissuading employees from reporting injuries, and then taking negative action against them if they do report injuries. The overall idea here is that OSHA tends to disfavor rate-based incentives and bonus programs. So like injury rates, either falling below a certain rate or having zero injuries. OSHA tends to disfavor those types of standards being used for incentives and bonuses, or even disincentives, because it believes that that would discourage an employee from reporting an injury or illness because of the fear that they would, raise the rate to a place where the bonus would not be provided to everyone else, bring the rate above zero, whatever the standard might be. So you'll see bonus for employees or crew for having no injuries. OSHA tends to disfavor those types of incentive programs, whereas if the focus of the incentive program, the standard that's set for receiving a certain incentive or a bonus, is a safety related factor, promoting reporting of hazardous conditions, or participating in safety training, raffle in the month that employees comply with a legitimate safety rule. So we have no issues with non-compliance with a safety rule, or giving bonuses for employees who are observed working safely, who have finished their safety training or joined a safety committee. Those are all things that are considered safety related, positive factors that OSHA believes contributes to a culture of safety and would not dissuade someone from reporting an injury or illness. So they tend to favor those types of programs. And those types of programs are not going to be something that are seen as problematic under the anti-retaliation provisions, whereas rate-based programs can be, unless the employer also has other precautions in place to make sure that employees know that they should be reporting injuries and illnesses, and to in another way promote reporting of injuries and illnesses, which we will review in this next slide. Because this is actually more of a recent interpretation that has come out during the Trump administration. So in October 2018, OSHA did issue a memo that it said clarified some of those restrictions and prohibitions around safety discipline, safety incentives, and post-incident drug testing. And I think the most significant change in that memo was the application of the anti-retaliation provisions to these types of incentive and bonus programs. So what OSHA says in this memo is basically that a rate-based approach can be okay, can be permitted under the anti-retaliation provisions, but it needs to be implemented in a manner that there are also precautions that are implemented in conjunction with the program to ensure that the overall approach doesn't deter employees from reporting injuries and illnesses. And so within this memo, OSHA gave some examples of the types of policies that can be implemented along with a rate-based approach that would offset the deterrent effect that that approach might have. So the first is incentives for IDing unsafe conditions. We talked about that a little bit in the previous slide. OSHA sees sort of these safety related incentives to be important in promoting employees to take, certain safety steps, and would sort of counterbalance consideration as far as reporting an injury or illness because of a rate-based incentive. Having a training program for employees to reinforce reporting rights. So if an employer is going to have either, a component of their incentive or bonus program be rate-based, they are also providing training to employees that, reinforces that employees should be reporting incidents, even if it would impact the rate. Employees are still expected to report injuries and illnesses, and, no retaliation will occur because an employee reports an injury or illness. And that training should be occurring anyway, related to the policy that the employer implements for reporting injuries and illnesses. But that's going to be even more important related to a rate-based approach for safety incentives. And then finally, having a mechanism for accurately evaluating employees' willingness to report. So, this might mean implementing periodic check-ins with employees, maybe on an anonymous basis, to see, whether injuries and illnesses are being reported, whether they feel comfortable reporting injuries and illnesses, whether they understand the expectation that they have to report injuries and illnesses. Again, if the employer has a rate-based approach, this again would counter, the potential deterrent effect of not reporting an injury or illness. So with that, we're going to move on to a discussion of the SST program. And then the next slide, you'll see SST is a site-specific targeting inspection program. So it is a type of programmed inspection, and it was implemented based on the E-Recordkeeping data in October 2018. That's when OSHA launched the first SST based on the data that it collected from the E-Recordkeeping program. And it's labeled the SST-16 because OSHA used the 2016 data to sort of set up who would be inspected per this initiative. The SST-16 inspection plan outlined OSHA's strategy to target certain establishments for inspection. And like I said, it used the 300A data from 2016. At the time, the 2017 data was delayed, and some of the 2017 data was still coming in. So OSHA didn't feel like it could rely on 2017 and solely relied on 2016 for this first iteration of the SST. It applies to all non-construction workplaces with 20 or more employees. And it uses software that generates a list of targeted establishments for enforcement from that pool of employers, that pool of non-construction workplaces with 20 or more employees. And the way it works is that area offices would get this SST software, and the software randomly selects establishments from the total that are eligible for inspection under the SST, and establishes the workplaces that OSHA needs to go and inspect during that particular cycle. The area office would then complete the inspection cycle. They would be expected to inspect all of the employers, all of the particular sites that are included in that cycle, unless they had to limit it at some point due to resource considerations. If they were not able to, they didn't have the amount of compliance officers or didn't have the financial resources to conduct all of the inspections that were listed in the cycle. The area office had limited authority to modify and delete those lists once they were established by the software. And the basic parameters for deleting certain establishments were really just If the establishment had already been inspected within a certain time frame of the scheduled inspection under the SST, or if they fell into certain programs with OSHA like VPP, then they could be deleted from the list as well. But those, there were just very few limited exceptions. Otherwise, if an employer fell into the constraints of non-construction workplaces where 20 or more employees and were included on the list by the software, then OSHA was expected to inspect those workplaces that were provided on the list. On the next slide, and this just gives a little bit more specifics on the site-specific targeting program itself. The inspections were intended to be comprehensive and were required to be comprehensive. So if a compliance officer came to the site per the SST program to conduct an inspection, they were looking at everything, all potential safety issues at the facility. Was wall-to-wall, facility-wide inspection. And it could be coordinated with any other national emphasis programs that the employer fell under. So if the employer fell within the parameters of the grain inspection program or the PSM inspection program, then the compliance officer could choose to do an inspection per the national emphasis program applicable to that establishment, as well as complete the SST inspection along with it. If an incident occurred at a site that was on the SST list and resulted in an unprogrammed inspection, if there was a serious injury at the site that was reported to OSHA, or OSHA otherwise received a complaint from an employee at the site about specific safety issues that led to an inspection, the compliance officer could also choose to do any unprogrammed inspection along with an SST inspection if that establishment was on the list generated for that area office. So the SST program could certainly be problematic from the perspective of resulting in a comprehensive inspection of the site, but also it could be done concurrently with a national emphasis program or an unprogrammed inspection as well. And then on the next slide, this one talks about who specifically would have been subject to SST inspections. Again, we covered that the establishment would have to have 20 or more employees, but there were sort of three main buckets that an employer could fall into to be subject to the SST list and SST inspection. And that is first, establishments with a DART rate above a threshold that was actually not established in the program, but just sort of vaguely referred to as, sort of a DART rate above the industry average. And it was actually different DART rates in the SST-16 program for manufacturing and non-manufacturing establishments. Could also be based on a random set of establishments that OSHA believes should have submitted data, but failed to do so. And then finally, a random sample of establishments that had unusually low injury rates. So, triggering a potential suspicion that injuries and illnesses are not being properly recorded. And so those employers could be subject to inspection. OSHA has implemented a SST-20, and that is something we go through on the next slide. And there are some sort of important differences between the SST-16 and the SST-20. If we could flip to the next slide. For the SST-20, the data that is relevant to selecting the employer is calendar year data submitted for 2017 through 2019. So the 300-day data that employers were required to submit through the E-Recordkeeping system for 2017, 2018, and 2019. And then similarly, those three buckets are pretty much the same, just based on a larger set of injury and illness data. And then they also included a fourth category, which is those with upward trending rates. So looking at calendar year 2017, whether the rate was above the industry average, and then whether that rate continued to trend up in calendar year 2018 and 2019. And if employers met that criteria, they could also be they would also be included sort of in the group of employers subject to inspection. And then if they get pulled onto the list through the software provided to the area offices, would be subject to an SST inspection. With that, based on time, I will turn it over to Eric to talk about COVID-19 record keeping.
All right. Thanks, Dan and Lindsay. Great job walking us through the electronic record keeping rule and SST. We did decide to get into a little bit of COVID-19 issues today because I think that we are likely to see a meaningful impact on the SST program, really on the employers who are subject to SST because of COVID-19 record keeping, or the potential that if employers are recording a substantial number of COVID cases, because those cases tend to almost always be days away, I would say, I can't imagine a scenario where they're not days away cases because even if someone is asymptomatic, if it's a work-related COVID case, you're going to have multiple days away recorded on the log. I think we could see a huge spike in employers' DART rates because of COVID and COVID record keeping. So we thought it was worthwhile to talk about it here because of the impact that may have on your DART rate, on the data that you're submitting to OSHA, which is publicly available, and then the impact that that may have on employers who previously were not subject to SST inspections because they were low DART rate operations, possibly getting swept in there because of big increases in their DART rate. So just as a basic level, we'll talk about COVID-19 record keeping. The first question, and this is pretty well settled now, but early on in the pandemic, there was a lot of question of whether, hey, is this even a recordable thing at all? Is this a recordable event if I have an employee who contracts COVID-19? The cold and flu have long been exempt from COVID-19, and I'm not suggesting at all that this is the cold or flu, but the reason why the cold and flu have been exempt from COVID-19 from injury and illness record keeping for many years is because it's really hard to tell whether those illnesses were contracted at work or somewhere else, right? Because a virus is invisible and it's ubiquitous. It exists out in our personal lives out in the world, and it exists in the workplace. So how can you possibly tell whether an illness like that was picked up at work versus somewhere else? Well, those same challenges, obviously you all have encountered this, I expect. Those same challenges have been faced by employers for the last year and a half, figuring out, okay, I have an employee who's now confirmed COVID positive. Where the heck did they get it? Now we had 2 or 3 cases in the workplace. Looks like those folks worked together, so it could have been here, but they also went out and did grocery shopping and went to the movies and went to restaurants and went to barbecues or parties at friends' houses. So how do I know whether this particular case is happened in the workplace? So for that reason, a lot of people pushed OSHA to exempt COVID-19 from record keeping, saying it's too hard to identify work-related versus non-work-related. And these aren't traditional workplace injuries like a machine that has fallen into disrepair that has been allowed to injure someone, or a chemical that we bring uniquely into our workplace that exposes, employees are exposed to and causes an illness. Those things that make sense to track on your 300 log because you can change configurations in your workplace and deal with these unique workplace hazard issues. And tracking those injuries and illnesses are helpful to identify things you might need to do to improve safety in your workplace. It's not always the case with COVID that there are things that you can or should be doing differently in the workplace that may have prevented a transmission of the illness. So for those reasons, a lot of people pushed to say this should not be a recordable injury or this should not be a recordable illness. And OSHA said, no, sorry, we're not going to exempt it outright from record keeping. And one of the main reasons, or maybe the main reason that I heard from folks at OSHA that they didn't just exempt COVID from record keeping is that they didn't think, as an agency, they didn't think they could lawfully do that. That the cold and flu exemption is not a policy. It is actually written into the regulation. It went through notice and comment rulemaking, followed the law to become the law, and just making a proclamation that this thing that is not the cold or flu is a different illness, a different virus, is exempt, would need to go through rulemaking. Now, I think they missed an opportunity to do that when they issued the emergency temporary standard earlier this summer, but they felt like they couldn't lawfully do it without a rule. They didn't have a rule at the time, so they said it's potentially recordable. It's recordable if these three criteria are met. One is it is a confirmed case of COVID-19, and OSHA defined confirmed case to mean at least one respiratory specimen tests positive for the virus that causes COVID-19. So that means a self-diagnosis or a doctor's diagnosis, a situation where 3 members of your household have tested positive for COVID-19, and now you have all the symptoms of COVID-19 but never got a test. That's not a confirmed case. It has to be a respiratory specimen tested positive for COVID-19. There's some debate about whether that requires an antigen test, a PCR test, rapid test, whatever. Our view is that it doesn't matter the type of test. And I'm happy to talk offline about the distinction there, but why we think that any laboratory-based or any test-based diagnosis is a confirmed case. Second is that the confirmed case results in one of the general recording criteria, which is treatment beyond first aid, work restrictions, things like that, and days away from work. And my view is that, unless you find out about someone's COVID positive case, weeks into, somehow weeks after they actually had it and they never excluded themselves from work and you never excluded them from work, essentially every COVID case is going to trigger the days away criteria because you're going to be quarantining or isolating an employee who is a confirmed case, who's tested positive, even if they're asymptomatic. In almost all circumstances, those individuals are going to have days away from work. And there's some nuance in there about employees who are already teleworking or already approved to telework for certain tasks or things like that. If they're already approved to telework and they are able to, because they are asymptomatic or experiencing only mild symptoms, continue to work in a telework function, then that may not trigger the days away criterion for record keeping. But if they were working in the workplace, coming to your brick and mortar establishment, test positive, and then all of a sudden start teleworking because of their positive test, and they weren't previously designated to be teleworking, even if they are doing every function that they would otherwise be doing in their job, even if their job tasks don't change at all and they're able to do everything, if they were not teleworking and now they are because of the diagnosis, then that constitutes days away and could be a recordable injury. It's the third criterion, though, that is the one that has been most challenging, but also the reason why many, or most, or almost all COVID cases have not been recordable, or there's a credible argument to be made that they're not recordable, and that is that they have to be work-related. And as we discussed at the very beginning of this section, that is extremely challenging for something like this, an invisible, ubiquitous virus that now is, measured in the hundreds of millions of cases. How do you tell whether a case is work-related? Well, OSHA has kind of bounced all around the map on whether COVID cases are work-related. We'll start off with not even their first position. This is the second position that the agency landed on that really has been the primary guidepost for determining work-related COVID cases for most of the pandemic. And that is, you are still required as an employer, if you have an employee who experiences an illness that might be work-related, it has the potential to be work-related, and it results in those other criteria, you have to do an analysis about whether it's work-related. The very beginning, it was only healthcare employers that even needed to analyze this. But for most of the pandemic now, all industries, all employers at least have to do an assessment, analyze, is it more likely than not that it was an exposure in the workplace that was the exposure that caused the illness? And how do you do that analysis? OSHA says, look, we're not expecting you to undertake an extensive medical inquiry, given employee privacy concerns and a lot of the challenges in doing that kind of assessment, but you have to do some sort of assessment. It may be enough to just ask the employee how he or she believes that the virus was contracted. Do they have some clear understanding that they were at a party over the weekend with 2 other people who had turned out were COVID positive, and they didn't have any identifiable exposure at work? Well, they believe, or you could discern from those facts, that it was more likely than not that it was not a workplace exposure that caused the illness. So find out what the employee thinks, but also evaluate the employee's work activities, work environment, as well as any out of work, non-work activities. Like, did they attend parties? Did they do the grocery shopping? Did they have someone in their home who works with the public or works in healthcare, or who has already tested positive before they did? Doing that kind of analysis would help you get to the answer as to whether it's more likely than not that it was a workplace exposure that caused the illness. And you review that employee's work environment. Do we have effective distancing in that work environment? Do we have, mask requirements, and are they being adhered to? Do we have lots of interaction with the public? Do we have any other positive cases in that same work area? That's the kind of analysis OSHA is expecting employers to undertake. That guidance also provided, some additional guideposts for what OSHA thinks looks like a case that is more likely to be work-related than not, and how you do that analysis. They gave some specific examples. And the specific examples are basically a cluster or outbreak would be one indicator weighing in favor of work-relatedness. So if you have several cases among workers who had close contact with each other, among workers in the same area of the workplace, that would tend to indicate work-relatedness. Another example was the illness was contracted shortly after a longer-term exposure to a single individual who it turned out was COVID positive around the same time. That would be an indicator of it being more likely than not to be work-related. And the third example OSHA gives is that if the job task the employee has involves regular, frequent, extended exposure to the general public, where you may not know that there was a specific COVID positive person that they interacted with, but they're interacting with a lot of people in the public whose status you just don't know, that would be a good indicator that their positive diagnosis is work-related. However, one thing maybe you saw on the slide here, the italicized language that was provided by OSHA with every single one of those examples, those are things that might indicate a likelihood of work-relatedness. However, OSHA says those would likely be work-related provided there is no alternative explanation for the illness. Now, there's a lot of different ways to read that. You could read that to say, well, my gosh, there's always an alternative explanation. The employee doesn't live at the workplace. They walk out onto the streets where there is this, rampaging pandemic, where there is substantial community transmission. The mere fact that they also interact in the world is enough to say that there's always an alternative explanation. We know what OSHA's expectation is there is that there needs to be an identifiable non-work explanation. And if there is an identifiable non-work explanation, meaning they were at an event, a party, a barbecue, at a restaurant, at an event where there was it turned out after the fact you learned that somebody else there was COVID positive. Well, now you've got a credible alternative explanation. So even if you work, for example, let's say you're in the shipping department on shift 1 at your facility, and there's 10 employees that work on shift 1 in the shipping department, and 8 of those 10 employees all got COVID right around the same time. Well, OSHA is going to say, my gosh, look at that. That's a clear indication of workplace transmission. You've got an outbreak, a cluster in this group of individuals that work closely together on the same shift at the same time in the same area of your workplace, that is more likely than not work-related. However, if 2 or 3 or 4 of those individuals in that group have other credible alternative explanations, like a family member who was also sick around the same time, like an event that they went to where there was, someone known to be COVID positive, or they went to some sort of mass gathering event. To me, I think that's good enough that if you're at an event where there are hundreds of people indoors and you may not know that there was a COVID positive person around you, that is a substantial exposure. You traveled, you were on an airplane, things like that would be a credible alternative explanation that would make even a somewhat, sort of smacking you in the face workplace exposure, any alternative explanation that is credible would undermine that finding. And that's the analysis we've been doing with our clients throughout the pandemic. OSHA also provides some interesting examples of things that are not likely to be work-related. Those would be cases where you've got one worker in a general area of the workplace, one worker in that shipping department on shift 1 tested positive and nobody else did. Well, if nobody else did, then why do we have reason to believe that it was transmitted at work? Because there's not, another person from whom it may have been contracted. So one person in a general area, not likely to be work-related. The job duties of the individual employee don't involve frequent contact either with other workers or with the general public. If they work generally isolated on their own at the workplace, that's not likely to be a work-related case if you don't have a clear workplace exposure identified. And then if you have examples of outside the workplace, the infected employee associated closely and frequently with someone outside the workplace who tested positive. That's that credible alternative explanation we talked about before, that would undermine any finding of work-relatedness regardless of what was going on at the workplace. Well, recently that guidance changed, sort of. The agency took what had been sort of a standalone piece of guidance about OSHA record keeping, a memorandum to their field offices about COVID-19 record keeping. And when they updated their recent guidance, they also updated their interim enforcement response plan and moved their record keeping guidance into that response plan document. So they archived that guidance that I've been relying on since May of last year to guide employers through this record keeping analysis. And it changed somewhat in the sense that it got much leaner. There's a lot less detail. OSHA doesn't really provide the examples like they provided previously, but they do still provide that same caveat that anything that is more likely than not to be work-related needs to be balanced against an alternative explanation. So it's the exact same qualifier. So to me, even though they've relocated the guidance and made it, frankly, less helpful because there's less detail to it, I think it hasn't changed in a substantive way. The analysis is still, first, is there an identifiable, credible workplace exposure? If so, maybe it's more likely than not to be work-related unless there's a credible alternative explanation. If you have that credible alternative explanation, then it's not work-related. That's the analysis we've been doing. The last thing I would just point out about this, we didn't get in a ton of detail about it in these slides, is that there is an emergency temporary standard for COVID-19 now, but it is limited only to healthcare. And it made some really meaningful changes to record keeping. It created a whole new log that healthcare employers are required to keep to document all COVID-19 cases involving your employees, even if they are sort of 100% known to be not work-related. You are still putting it on this separate log. We'll call it the COVID-19 tracking log. But it also, in the context of the ETS, provided guidance for healthcare employers about doing this work-relatedness analysis that they have to do. And our view is that that guidance, even though it's about the ETS doesn't change record keeping for the 300 log for COVID cases. So the guidance is useful for everybody. And the big takeaway, there's a lot of words on this slide, but the big takeaway from that is that concept that I've been harping on here about the alternative explanations, non-work explanations, that lived on and it was re-emphasized again by OSHA in its guidance about the ETS. You can see it bolded at the bottom here, that these things are likely to be work-related, especially in healthcare, especially for an employee in healthcare who is working with COVID patients. OSHA is going to expect that you are going to find almost all of those cases to be work-related. However, you don't have to find it work-related if there is evidence suggesting there was an exposure that occurred outside the workplace. So again, it's this concept of looking not only at what happened at work, but what happened outside of work. And if you have any credible explanation for how someone got sick outside of work, and since the thing is invisible and it's everywhere, I've got one exposure at work or maybe 50 exposures at work, but one really credible one away from work. Well, how do I know which one was the one? I don't. So I can conclude that's not work-related. That's how I've been doing this analysis. Now, I'll tell you, we've got employers who have also been all over the map on this. We have some employers who said, the analysis is too hard and I just don't care to get it wrong. I don't want, to someone come in and criticize and say we were hiding cases. So we're just going to record essentially all COVID cases. And we've got other employers who are out there going through a lengthy questionnaire, one that we put together, to identify examples of non-work exposures that might have occurred that might represent an alternative explanation, and who are recording practically no COVID cases because it's not that hard to find credible alternative explanations for how someone got sick. Now, there's pros and cons of both of those strategies, but one negative to recording a bunch of COVID cases, I mentioned at the very beginning, is those cases are on your log, they go on your 300A, they are uniquely identifiable because there's a column on your 300 log and in the 300A for respiratory illnesses. So it's going to be very clear that you've had a bunch of respiratory illnesses in 2020 and 2021. People will be able to connect the dots that you had a bunch of COVID cases. And that may subject you to negative media, potentially plaintiffs' attorneys poking around, competitors using these things to your disadvantage, impacting your ability to recruit and retain employees. A lot of reasons why having a bunch of recorded respiratory illnesses would not be helpful. But the other big one, and this was what Lindsay talked all about, comprehensive wall-to-wall inspections under the site-specific targeting program. A bunch of COVID cases likely means more scrutiny from OSHA. It's going to be a big increase in your DART rate, which may make you subject to SST, but also just having all those cases may have you subject to an OSHA inspection just about COVID. They've got a COVID-19 national emphasis program, and recording and reporting a lot of COVID cases would likely result in a bunch of exposure or a bunch of interactions with OSHA. So that's our presentation for the day. I encourage everyone, especially during the pandemic, to check out our blogs, the OSHA Defense Report blog, the Cal OSHA Defense Report blog, and our Employer Defense Report blog. We are, working harder than ever to keep the blog fresh with important information, mostly about COVID-19, because that landscape is changing on a daily basis. We've tried to utilize the blog as a great tool to keep our clients and friends in industry updated about COVID developments or any OSHA developments. And we're probably going to see some good old-fashioned traditional OSHA developments with the Biden administration, some new rulemaking, new enforcement programs. So I definitely encourage everybody to sign up for the blog. You'll get an email every time a new article posts, or just go check it out. And then, of course, to continue to join us for our monthly OSHA-related webinars in our 2021 OSHA webinar series. If you sign up for all of those programs, we do occasionally, or actually kind of frequently, add new topics when something really important develops that we didn't anticipate. When we put our calendar together, those are often COVID-related developments. So register for all of the events, or send us a note to ask to be registered to all, in which case we will get you added to any new programs that we add to the calendar as well. And then finally, I want to make a request that you all go and check out and subscribe to our YouTube page, the Kahn Carey YouTube page. We've got a goal of getting to 1,000. We're very close to it, and I encourage you all to do that. If you do that, you will get a notification each time a new webinar recording is added to the page. So if you didn't register for one, you missed one, and you want to go check that out after the fact, they're all there, and subscribing to the page is a great way to keep up to date on that. So I think we've run over our allotted time, as we do basically every month. Apologies for that. But if you have any questions that you haven't asked yet in the chat function, please don't hesitate to email or call Lindsay, Dan, or me. We're always happy to talk about this sort of stuff. Really want to be a resource to you for any OSHA issues, record keeping, OSHA inspections, whatever it is. We're here to help, and would love to be that resource. So thank you, everybody, for joining us, and we look forward to talking with you again soon. Stay well.